5 seconds to go. Start. A failure to create a conducive environment is a failure to provide reasonable accommodation. Section 2H of the RPWD Act defines discrimination in the context of disability as any distinction, exclusion, restriction on the basis of disability which has the purpose or effect of impairing or nullifying the recognition, enjoyment, or exercise on an equal basis with others of all human rights and fundamental freedoms in the political, economic, social, cultural, civil, or any other field, and includes all forms of discrimination and denial of reasonable accommodation. The denial of reasonable accommodation is expressly recognized as discrimination under the RPWD Act. For the proper realization of reasonable accommodation, a person with disability must be identified using correct parameters, and thereafter the accommodations necessary have to be determined on a case by case basis. Justice K.V. Viswanathan, speaking for this court in Omkar Gond Supra, has applied a purposive interpretation to the guidelines Appendix H1 in the context of a medical aspirant with dialectic incapacity. This court held that the principle of reasonable accommodation in Section 2Y of the RPWD Act, read with Article 41 of the Constitution, necessarily means that a person cannot be disqualified merely on the basis of a benchmark quantification. Such a criteria would be unconstitutional for being overbroad. The Disability Assessment Board must not act as monotonous automations looking at the quantified disability and disqualifying candidates. The board must examine if the candidate can pursue the course with their disability, and in doing so, the board is not merely obliged to provide assistive devices and other substances which will help the candidate. The true role of the board is to assess the competence of a candidate. The principle of reasonable accommodation is not only statutorily prescribed but also rooted in the fundamental rights guaranteed to persons with disabilities under Part 3 of the Constitution. Reasonable accommodation is a fundamental right. It is a gateway right for persons with disabilities to enjoy all the other rights enshrined in the Constitution and the law. Without the gateway right of reasonable accommodation, a person with disability is forced to navigate in a world which excludes them by design. It strikes a fatal blow to their ability to make life choices and pursue opportunities. From mundane tasks of daily life to actions undertaken to realize personal and professional aspirations, all are throttled when reasonable accommodations are denied. Reasonable accommodation is a facet of substantive equality, and its failure constitutes discrimination. In Vikas Kumar versus UPSC, this court adjudicated on whether a person with a writer's cramp is entitled to a scribe for writing the examination. Allowing the use of a scribe, this court held that the benchmark standard can only be applied where expressly stipulated. Section 2S of the RPWD Act defines a person with disability as a person with long term physical, mental, intellectual, or sensory impairment which, in interaction with barriers, hinders their full and effective participation in society equally with others. Therefore, a person to be considered as a person with disability does not have to qualify any benchmark. The principle that the rights and entitlements cannot be constricted by adopting a benchmark as a condition precedent was also upheld by this court in Avni Prakash versus NTA. Section 3 of the RPWD Act affords persons with disabilities a right to equality and non-discrimination. In Vikas Kumar Supra, this court held that Section 3 casts an affirmative obligation on the government and private entities to take steps to ensure reasonable accommodation and utilize the capacity of persons with disabilities by providing an appropriate environment. There is a positive obligation to realize the inclusive premise in the concept of reasonable accommodation. This includes the duty to create an environment conducive for the development of persons with disabilities. This court has held that the accommodation which the law mandates is reasonable because it has to be tailored to the requirements of each condition of disability. The expectations which every disabled person has are unique to the nature of the disability and the character of the impediments which are encountered as its consequence. Failure to meet the individual needs of every disabled person will breach the norm of reasonable accommodation. Flexibility in answering individual needs and requirements is essential to reasonable accommodation. The principle of reasonable accommodation must also account for the fact that disability based discrimination is intersectional in nature. The intersectional features arise in particular contexts due to the presence of multiple disabilities and multiple consequences arising from disability. Disability, therefore, cannot be truly understood by regarding it as unidimensional. In Ravinder Kumar Dhariwal vs. Union of India, while dealing with a case of a CRPF officer with a mental health condition, this court had the opportunity to opine that disability is a social construct. Its manifestation is contingent on the manner in which it interacts with inter alia social, economic, and historical factors. A one size fits all approach cannot be adopted in assessing disability. Disability is not a universal but an individualistic conception based on the impairments that a person has along with the barriers they face. Since the barriers that every person faces are personal to their interpersonal and structural surroundings, a general observation of permissible behavior cannot be made. Central to the principles of reasonable accommodation and the individualized experience of disability is the right to access legal protections without due mental hardship. If persons with disabilities must repeatedly turn to the courts to correct the missteps of authorities, then the rights recognized by this court and the RPWD Act risk becoming hollow assurances. For every person who has the awareness or ability to move this code, there are numerous others who suffer in silence. In the present case, the appellant was subjected to protracted and mentally exhausting assessments that failed to apply the correct standards, leading to a declaration of ineligibility. His first journey by air was not for leisure or education, but to undergo a medical assessment in Delhi by an order of this court. In this process, valuable time was lost and the appellant faced intrusive and irrelevant questioning. Persons with disabilities often confront systematic failures that engender a deep sense of disappointment, a disappointment that reflects the frequency and predictability with which the system fails them. Those with disabilities who aspire to succeed must not only plan meticulously but also brace themselves for the barriers they will inevitably face due to their disabilities. For many persons with disabilities, the stress of medical visits, the frequent trips to hospitals, the constant readiness to attend appointments, the long waits, the uncertainty of a doctor's availability, and the anxiety over the results forms part of their lived reality. At the very least, they deserve a process and an outcome that is fair and reasoned. The mental toll which processes before a medical board has on people is recognized by this court. In A. Mother of X versus State of Maharashtra, this court had the opportunity to opine on the shifting stances of medical boards which are often observed in cases relating to medical termination of pregnancy. This court held that the lack of application of proper standards, simpliciter recantation of statutory provision, and changes in opinions cause undue mental trauma to the pregnant person. Stop.